Ladies and gentlemen, hit subscribe to H.A. Goodman's other channel right now. We had about 1,000 live stream viewers on H.A. Goodman. It was fantastic. The live stream is below in the pinned comment. Ladies and gentlemen, this is huge. Appeals court revives Trump effort to fight hush money conviction in light of Supreme Court immunity ruling. It's going to federal courts. It's going to a federal appeals court. If it goes to the Supreme Court, it'll be overturned. When it gets to the federal appeals court, it'll almost certainly be overturned. If it stayed in New York, which it was never going to stay in New York forever, because the state cannot level. No state can level an FEC crime without the Department of Justice involved. No state can level a Federal Election Commission crime without the Department of Justice involved. Check this out. Hit subscribe to H.A. Goodman's other channel. This is huge, ladies and gentlemen. The Supreme Court essentially has already overturned the hush money conviction, and here's why.
I have the same reaction Francie Hakes does. This is a travesty, a miscarriage of justice. This was a phony prosecution from the very beginning. And for this jury, think about how many weeks this trial went on, how many witnesses came in, and in the very short time that the jury was out, they decided he was guilty on all 34 charges. This is a damage to the reputation of the American justice system like we have never seen. I have a colleague just got back from a conference overseas, and the reaction of lawyers and people there was that the United States has now gotten to be like the countries they are from, where the government uses its law enforcement powers to go after its political opponents. And that, I think, is exactly what happened here.
Hans, what was the underlying federal campaign violation? Did we ever find that out?
Well, there was nothing in the original indictment about any kind of federal campaign violation. They kept saying that the legal expenses, which is what were listed in the business records, should have been a campaign-related expense, the payment that was made to Stormy Daniels. But as Brad Smith, I know, would have testified, under the test applied by the FEC, this was not a campaign-related expense, period. There's just no question about that. So for this jury to say that, oh yeah, he violated federal campaign finance laws and that justifies the underlying verdict, that is such an egregious mistake.
Also, the misdemeanors were record keeping, and then they elevated misdemeanors, record keeping misdemeanors, to felonies, 34 felonies, because the accusation was that he was trying to commit a federal campaign finance violation by paying Stormy. But that would not have been a campaign finance violation. Check this out.
That at the Court of Appeals in New York, when they get this case, they ought to reverse this almost immediately because of this and so many other mistakes made in the case.
How many do you count? How many mistakes?
I lost count of how many errors were made by this judge and by the prosecution. I mean, the judge let in all kinds of irrelevant evidence that had no bearing on the charges against the president, but were obviously there to blacken the character of Donald Trump. The judge shouldn't have even been on the case. He should have recused himself because of his personal family dealings, his daughter's involvement, his making political contributions in violation of the ethics rules in New York. There are just so many mistakes and errors he made that I don't see how a Court of Appeals could not overturn this verdict.
And so it wasn't a campaign finance violation, but check this out. John Yoo explains how a state cannot level an FEC crime at anyone.
By the time the appellate process catches up with me, so be it. They're going to time it the same way. So this can really become a cancer on the political campaign system of the highest federal official in the United States. And the election there, too, no?
Mark, I appreciate what you said in your opening statement, because the Supreme Court has made clear, not just in one offside comment, in 3 very clear decisions, that only the federal government can enforce federal law. Only the Justice Department and the Federal Election Commission can prosecute and bring suit for violations of federal election law. They're the guardians of how federal election should run. And so what happened here is that the DA, approved by this judge, Judge Merchan, grabbed the authority away and basically decided to prosecute his own interpretation of federal law. That's not permissible under our separation of powers and federalism, and the Supreme Court will reverse if, as you say, Mark, they get a chance to hear this case.
So the Supreme Court will reverse it when it gets to it, or the appeals court, the federal appeals court, will reverse it because there were so many problems with the case. Hit subscribe to this channel. This is huge. It wasn't even a campaign finance violation. Trade trainer, former FEC chairman, Bradley Smith, former FEC chairman, and you just heard Hanze von Spakovsky all stated it was not a campaign finance violation because a person would have paid Stormy to keep quiet about an alleged affair with or without a presidential campaign. That's why the FEC dropped the case and the DOJ dropped the case. And as you heard from John Yoo, it's completely unconstitutional for a state, after the federal government dropped the case, to accuse anyone or convict anyone of a federal crime. Hit subscribe to this channel, H.A. Goodman's other channel, right now. Go to the live stream below in the pinned comment on my other channel, H.A. Goodman, of almost 300,000 subscribers. Let's get to 20,000 subs here. Hit subscribe. Thanks so much, everybody.